locked. Okay, well, I tried to record it sideways, but it didn't work. So that's cool. So I'm gonna wait till people get in here.
How do you...
About to drop some heat. Yeah, live on YouTube.
Why are you on me?
Didn't have me for that to happen.
You know what that reminds me of? That boy that came to the temple, that was funny. That was funny. And we just all act like nothing happened.
When? Who?
Nah, I'll tell you after, off the live.
I was there?
Nah, you wasn't there. Nah. Peace. We're waiting for more people to join. We're gonna go over some federal stuff. Some federal court stuff. That more should be doing. Leonidas asks this question all the time. Why aren't there mores, flooded in the courtroom suing everybody? Especially since there's a lot of mores online pretending to know things or acting like they know things or, offering law classes or whatever it is that they're doing. Yet they're not in court suing anybody or helping anyone sue anybody or helping the mores sue anybody or anything like that. And, Juju could tell you there's hundreds and hundreds of messages on our iPad of people asking for help, texting our legal service. There's hundreds and hundreds of emails that we haven't even gotten to answer yet of people asking for help. So why aren't these people helping? Instead, they're going to sell you a class when they could be making a greater impact by just giving you the information. In the Quran that Noble Drew Ali gave to us, he said, I'm going to paraphrase, but it talks about how a master lays out their footprints to clearly show you that they've been there, to show you the way, right? Then it says, something like a block of wood can point in a direction too. So all these more saying do this, do that, and do this, and do that, and do that, and say this, and say that with no proof, a block of wood can do the same thing. All you gotta do is get a block of wood, carve in it whatever you want to say, and there you go. Right? Only true masters can get you something like this. And if you can't see that, it says United States District Court, District of Massachusetts, which is federal court. Now, the prophet said enforce the Constitution, right? In law, that's called raising the federal question. Where do you do that? In federal court. Can't do it anywhere else. You can enforce the state constitution in state court, but you can't enforce the United States Constitution anywhere else as far as determining if something's constitutional or not. That can only be done in federal court. That's why it's called raising the federal question. So, this is a deposition. It says it right here. Deposition of David Allen Pender, taken by the plaintiff. Who's the plaintiff? Leonidas Jabeer Bey. What does that mean? That means, one, you can file claims in federal court as a more in your free national name. What else? Two, that means you do not have to pay the courts no $400 filing fee. What else does that establish? Three, federal courts have to recognize Moorish IDs. Four, federal courts have to recognize Moorish consuls.
I was going to say that. I was going to say that.
Oh.
5.
So there you go. Four points right there. 4. So now what can the Moors do? The Moors can use the fact that Leonidas Jabir Bey versus the Commonwealth of Massachusetts and David Allen Pender as their decisive saying that we do not have to fill out IFP forms to have cases filed pro bono in federal court. Here's proof.
Yeah. We didn't,
That's case. This is case law right here.
We didn't film one of those.
Nope. Case law right here. And if you don't believe us, feel free to go to Pacer and pay for the information, even though we've already shown you this. But there's a lot of naysayers who say, well, whatever, you guys are making whatever it is that you're saying. Go ahead and pay the Europeans. Go ahead and make your Pacer account. Get all the records, and you'll see we have never filed any IFP papers. Just go to it.
Google is your friend.
Hold on, just in case they think that this is fake.
Wait, it's fake. You never opened it.
Yeah, right?
That's it. Original.
I don't know. I can't read.
They gonna be like, yeah, but it didn't say Aboriginal. They gonna be like, what? The file you say Aboriginal, so you know he a op.
You're ridiculous, but that's what they say. So you're not ridiculous. They're ridiculous.
Look at that seal. Oh, what does that say? Catherine? Catherine M. Burns.
Shout out to Catherine.
Right?
Just cause. Look, this is him. This is him signing it. And look at that signature right there. Oh yeah, good job. These are words that were used.
They done made a mini Bible.
If
in the
you've
back.
if you've never seen a deposition before, these are words that are used. So if you go to page 34, verse 14, you'll see the word feeling.
That joint is crazy.
I'm dead serious. That's how it
I
works.
know, that's just wild.
See Griffin. You want to find Gryffindor? Now it's Kyle P. Griffin or whatever his name is as a cop.
Gryffindor?
I'm just showing. Before we get to the juicy part.
And death related to the Bosnoveldorf.
Before we get to the juicy part, I kind of just want to show you some stuff. That's you saying you're sorry. This is it right here. This is the deposition right here.
Looking like a book.
So, the deposition is used to depose the other party's argument, right? So,
And what is depose?
depose is to like throw someone off their square, right? Like the deposition of a pope is the removal of a pope from office, right? So the deposition of a plaintiff or defendant is removing them from their entire argument based on what they say, basically, right? Based on, you know how they say everything can and will be used against you in a court of law.
Yes, it can.
That's where the deposition comes into play, where they're asking you specific questions. Where were you on the night of whatever? And then you say, I was here. But then they show evidence of you somewhere else. So now they're using your words against you. Right, so that's basically what a deposition is for, is to depose the other party. It's part of the pre-trial administrative proceedings that take place, obviously, before trial.
Hence the word preacher.
Yeah, we have until September 30th to file this. So does the opposing side, right? Then we have a certain amount of time to rebut each other's summary judgment. And we also have an amount of time to settle, which if we don't settle, then it goes to a pretrial conference where we submit evidence, ETC, and then trial. So we're still at the beginning administrative processes. It would have been in court, but due to the alleged coronavirus, it was done on camera.
The pandemic.
Yeah, the pandemic. So this would have only been the second appearance.
So when they made a list of things that the pandemic was going to save them from,
This wasn't one of them.
On the board it said, so it was like, indictments that Leonardo just be a babe.
All right, I'm gonna read it now. Any questions first? Any questions on anything I said so far? You should ask yourself, why are you paying other people for this information? That's what you should ask yourself. And then you should ask yourself, why don't I support Rise of the Moors when they're just giving me this information for
You
free?
getting it free 99.
Right. No questions? Cool. So this is the case number, right? See that case number? See that case number? It's the same case. Right. This is a writ of summary judgment. So we're not motioning anything. We're sending a command of summary judgment. The command is based off of the laws that were referenced in this document, because issues of law supersede issues of fact. So it doesn't matter if it was a traffic stop and he was arrested. That doesn't matter. The law is traffic stops are not crimes and are not arrestable offenses. So he shouldn't have been arrested anyway. So it doesn't matter. Nothing else matters except for the law.
Correct.
Right? You'll also see in the law book, this will be referred to as a judicial notice as well, because none of this can be disputed word for word. So as an example, today is September 25th, 2020, Friday. No one can say that's wrong. It's Friday. It's September. It's the 25th. It's the year 2020. Now we can argue the Muslim date, which is why it's right here. So it doesn't matter.
True. We cover all corners.
Because according to us, it's this date. According to them, it's that date. There you go. Judicial notice.
There you go.
According to China, it's a different date. But it doesn't matter. It's still Friday. It's still September.
And it's still 8/13.
Right? So judicial notice are facts that cannot be disputed, which the law cannot be disputed.
Okay.
That's why there's something called stare decisis and res judicata, which if you don't believe me, go to Google, Google search stare, S-T-A-R-E, decisis, D-E-C-I-S-I-S, space, law, L-A-W, dot Cornell, C-O-R-N-N-E-L-L, if I'm not mistaken, dot edu, which Cornell University is one of the most popular law schools within the United States. And then they'll tell you that stare decisis must be adhered to because it's precedent and it deals with estoppels and issue preclusion and claim preclusion. And it's used to save time. And it's used to deal with issues already adjudged, already adjudicated, decisions already made, to prevent multiple situations that are exactly the same from happening. So the fact that a traffic stop is not a crime could have saved thousands of people from going to jail if stare decisis was adhered to. And don't believe me, go to law.cornell.edu, since the FBI likes to ask Moors where they get this information from. Law.cornell.edu. Look up stare decisis. Look it up for yourself. Law.cornell.edu. Look it up. And if you're ever in the courtroom and the judge says, well, you're using different words and you're interpreting them wrong, let them know that there's a law library in that building. Let them know that there's Black's Law Dictionary in that law library. Also let them know that there's Black's Law Dictionary at the State House. Go ahead and look for yourself. You don't gotta believe anything I say. I don't really care if you believe it. Don't care if you believe it or not. Why? Because the sun doesn't care if you believe it's hot or not. The sun is going to give you judicial notice that it's hot. It don't matter what you think. Right? So, summary judgment. Writ of summary judgment. So we're commanding a summary judgment. All right, I'm going to read it to you. This writ of summary judgment is being made pursuant to the common law principles contained in the Federal Rules of Civil Procedure, Rule 56. So look this up. Look it up. Hold on 1 second. So hold on, let me go in there and give you the scoop. So the reason why this is civil and not criminal is because this was done when they tried to continue with the state at the state level And since a traffic infraction is not a crime, we had to remove it to federal court under civil, because that's what it is. And if you don't have this book, get this book. I am Amazon. I think it was like 9 notes or something like that, something crazy cheap. So, although we have this information and you can call us for consultation, you do not need us. You do not need to pay us for anything. You can study this for yourself. And guess what else they have? Federal Rules of Criminal Procedure. And you can get that yourself too. You do not need Rise of the Moors. You don't. The savior is self, yourself. So save yourself, which means you get this information. Don't get mad because we can't answer all 9,000 messages that we get. Don't get mad. Save yourself. Same way we study law, you can study the law. You can't say we don't give you reference points because here's one right here. Right? The defense has no genuine dispute as to any material facts. Therefore, I am entitled to judgment as a matter of law based on the following facts. Fact 1. The defendant, meaning David Allen Pender, knowingly and intentionally used unnecessary force by treating a traffic infraction as a crime by approaching my parked vehicle with a taser in his hand and aggressively yelling, "Is this what you want?" When this fact was brought up in federal court, the judge verbally expressed concern as to why the defendant had a taser drawn and ready at what was supposed to be an ordinary traffic stop. The defendant is barred from claiming that, quote, the defendant has no knowledge that said alleged acts were illegal and or unconstitutional, unquote, which is directly from his attorney, as he claims to be a law enforcement officer, right? So he cannot claim that he didn't know he was violating the Constitution or acting illegally, right? Because he's claiming to be a cop, right? As stated on July 23rd, 2020, under oath, the defendant, David Allen Pender, is on record stating the following. Page 6. So let's go to page 6. All right, so look. This is not our record. This is someone else's record. This was done by a third party. Oh, just so you can see that it's not a copy. If it was a copy, the ink would not have gone through like that. So just so you know, it's an original. Only originals do that. All right. The date, all right? David Allen, sworn in. All right, let's go to page 6. Page 6. All right. Where is it at? Right here. Right there. Just so you can see that something's being referenced here, and here it is. All right, this is how a deposition works. So, when he was sworn in, this is what was asked of him. Right? So the question is Leonidas. So you're a law officer. So you enforce the law, correct? His answer was correct. Okay, so you would know some law, seeing as you enforce it. He said, I hope so, yes. Right? So there he is on the record saying that he's a law enforcement officer. He enforces the law, and he knows the law. That's what he said. That's what David Allen Pender said himself. A question was asked, he gave the answer. A question was asked, he gave the answer.
Q&A.
All right? So continuing. So that entirely removes his argument, well, he didn't know that what he was doing was unconstitutional because he just said he knows law. That's what he just said. Yes.
I hope so, yes.
Doesn't matter. The yes is the only part that matters.
I know.
He said yes.
And the yes takes the whole sentence. Yeah, he does.
Right? Since he claims to be a law enforcement officer, he is bound to know law, and the doctrine of ignorance of the law is no excuse applies to him in his personal and official capacity, both on and off duty. See Barlow versus the United States, Germain versus Carcel, McNelly, Rennie, Carmer, and Irk, People versus O'Brien, and People versus Snyder, criminal number 22293, Supreme Court of California, October 18th, 1982, which states it is an empathetic postulate of both civil and penal law that ignorance of a law is no excuse for a violation thereof. If a person accused of a crime could shield himself behind the defense that he was ignorant of the law which he violated, immunity from punishment would in most cases result.
Don DeMarco.
Ignorance of the law is no excuse in any country. If it were, the laws would lose their effect because it can always be pretended. Thomas Jefferson.
Shit like that.
So, shit like that. URL presents Leonidas Jabir Bey versus David Allen Pender. Strengths on the plaintiff's side are creativity, native blood, aboriginal DNA, and locks of hair, and of course, the infamous Moorish red fez. Strengths of the defendant are none. Right? Additionally, as a law enforcement officer, as he claims to be, pursuant to the full faith and credit clause of the United States Constitution, which all officers are bound to by oath or affirmation, the defendant must be familiar with the fact that traffic infractions are not a crime. See People versus Battle. Therefore, no taser should have been drawn, nor should I have been punched in the face. Therefore, I am entitled to relief. Right? So since a traffic infraction was treated as a crime and he stated to know law, which the law says a traffic infraction is not a crime, you are entitled to relief.
That's a fact.
The defendant's actions are clear indicators and proof of excessive and or unnecessary force used without warrant or cause and a blatant disregard for my rights protected by the Constitution. The defendant is also barred from claiming that, quote, the defendant has qualified immunity from this suit as the alleged acts complained of occurred within the scope of the defendant's official duties, unquote. And again, that's a direct quote from him via his attorney. As the defendant alleged he was responding to a traffic infraction, yet it is stated in Michigan versus Duke that police power extends only to immediate threats to public safety, health, welfare, etc., which traffic violations are not immediate threats to public safety. See California versus Farley. So he was obviously not within his official duties because he violated his official duty by treating a traffic infraction as immediate threat to public safety. Since traffic violations are not crimes, which the defendant is basing the entire altercation on criminal activity, it is prima facie evidence that the defendant had a predisposition to use excessive force and is barred from basing his unnecessary use of force on my alleged conduct, as he lacked jurisdiction to even engage in said stop, as it was not an immediate threat to public safety, nor can the defendant prove that it was. As stated on July 23rd, 2020 under oath, the defendant, David Allen Pender, is on the record stating the following. Page 7. So let's go to page 7 real quick. Page 7. Let's see, page 7. Page 7. Let's see if I can find it real quick. Boom, right there. Page 7. So these are his words. So just plainly, is a law and a code the same thing in your eyes? He said, no. I would say I would say they are not the exact same thing. No. Okay, and how long have you been an officer? Approximately 33 and a half years. Page 17. Let's go to page 17 just to show you real quick. We're not making it up. We're not making this up. This is what he said. Under oath. Under oath. So keep that in mind. Under oath, he said this. Under oath. Page 17. Okay, where is it? Na-na-na-na. Okay, and the reason engaged in the pursuit. Where is it real quick? Right here. Page 17. Right here. All right. This is what was stated. What was the reason you engaged in the pursuit? Did David Allen Pender answered, I attempted to pull you over for a marked lanes violation and an illegal lane change. Question. A marked lanes violation? Answer. That is correct. Remember, the answer is David Allen Pender. Question. An illegal lane change? Answer. Correct. Which are civil or criminal? Answer. Those are civil. Oh. Oh, civil. Civil.
What?
And the lane change? What's the other one? It's 89.4A was the marked lane violation, and 89.2 is the unsafe lane change. And that's also civil, correct? That is correct. So traffic infractions aren't crimes. According to this cop under oath. Oh, wait, just in case you don't believe it. Hold on, let me show you. That's also civil, correct? That is correct.
Correct.
So if you ever want to use some stare decisis or some res judicata, feel free to use David Allen Pender or Lee Nice Jabir Bay versus David Allen Pender.
Don DeMarco.
Oh, can you get that real quick?
Shit like
Just like that. Oh,
Just
shit like that. My
that.
bad. Shit like that.
Shit like that. Is this one?
Yeah. Hold on, we ain't done yet.
Don
So page 41 to 40, or 40 to 41. At what point did I become a criminal? When you failed to stop for a police siren and blue lights. You broke several laws when you did the marked lanes and unsafe lane changes. So at that point, by the time I pulled into the driveway where you pulled into, you were already under arrest in my mind. Oh,
in his mind.
you were going to be placed under arrest. So I just showed you case law where it says speeding, no plates, none of that stuff is arrestable offenses. Traffic infractions are not crimes. But in his mind, you were already under arrest. which he violated the law already, right?
Period, of course.
Then you said, oh, but that's in your mind. He's answered, that's all that matters when it comes to arresting somebody, is what I think. This is a cop under oath saying that. It's not what you think, sir. Right? So then you said, it's not what you're, and then you got interrupted. Then he said, it's not what you think. You broke the law and I was going to arrest you. Then you said, hold on. It's not what the people pay you to do. It's not what your codes and regulations order you to do. It's what you say, question mark? He said, it's exactly what it is. So now he's a thug, right? It is what it is, bro.
He got gangster.
It is what it is, bro. The law says if you fail to stop, you're subject to arrest. Which, that's not what the law says. The law says traffic infractions are not crimes. The law says no plates, speeding, etc. are non-arrestable offenses. Then you said, is it civil or criminal? He said, you failed to stop. Then his attorney said, hold on, because of course he doesn't want you to answer that. So his attorney stepped in and said, hold on. Then he answered you, it doesn't matter. You are under arrest. Then look, California versus Farley. Speeding, driving without a license, wrong plates or no plates, no registration, no tags, etc., etc., which includes what? Lane change violation and unsafe lane change,
And driving without a license.
have been held to be non-arrestable offenses. California versus Farley. Or California versus Farley. But in the cop's mind,
Mine.
it doesn't matter. In his own mind, the law don't matter. This is a cop, under oath. A cop, under oath. Look, cop, that's a cop. Hold on, let me show you. Just in case you don't know, Jamal, you're making it up. Let's go to page 41.
It must be a retired.
Hold on, let me show you.
It's a current
Let me just update you on David Allen Pender real quick. David Pender, right? sworn under oath, right? He was sworn under oath, right? He was sworn under oath and said he's a cop, Lowell police officer, right? That's what he said. Let's go to page 40, see where he said it doesn't matter what you think. It only matters what I think. The law don't matter. It matters what I think. 40 to 41, right? At what point did you become a criminal, right? Just read that. He answered, right? He was going to arrest you anyway. He already had full intentions. So that's called a predisposition. So he already had the predisposition for violence because he already said, as soon as you fail to pull over, you are a criminal. That's what he said.
Yeah.
That's what he said.
He don't know.
Even though California versus Farley, traffic infractions aren't crimes, in his mind, you're a criminal.
I could have been having a seizure. My foot jammed on the job. Like, I could have been going through anything in that job.
All right, that's all that matters when it comes
But
to
in
arresting
his
somebody is what I think. That's what a cop said.
He just read. He is the law.
Right? That's what he said. Under oath. That's what he said under oath. That's what a cop said under oath. He's still employed today.
Yep.
Right?
Still
David Allen Pender, an officer who out of his own mouth admits to knowing law and knowing that a traffic stop is a civil issue, violated the Sixth Amendment and State versus Edwards, which states that in order for crime to exist, there must be an injured party. Fact number 2. Also, that was just fact number 1,
That was just fact number 1.
and he's blown out the water already.
Oh. Already dug himself a huge
Oh, see, so these are just extra daggers. All right, cool. The information provided regarding the defendant's past of abusing his wife, see article from thelowsun.com and attached as exhibits. Although after being placed on administrative leave, his wife, Melissa Pender of 18th Street, dropped the charges after David Pender signed an accord and satisfaction agreement, that's what they called it, which meant that Melissa Pender will not press charges and in no regard means he was not guilty of said charges. So just because she stopped pressing charges did not mean he was not guilty. Because if you read this article, this happened at 12 a.m. Excuse me, was it? No, it wasn't 12 a.m. It was New Year's Eve at like 3 a.m. or something like that. If you read the newspaper article.
Yeah.
So obviously it was a New Year's Eve party. He got drunk and did something crazy. Obviously. Because ain't no normal person up at no 3 a.m. or whatever the time it was during New Year's and they're not drinking. What are you doing? What are you doing up?
Like up beating his
What do
wife.
you? Yeah, exactly. Right?
I already drank. Now I'm beating my wife.
According to the article published January 23rd, 2013, and updated July 12, 2019 at 12 a.m., the accord and satisfaction document stated, the complaint acknowledges that she has been satisfied as to any and all injuries
Jesus, that poor woman.
arising out of the incident, which is the subject of the complaint. And then I put the source.
Can you say blackmail?
Can you say beating your wife during a New Year's Eve party?
I already said that.
And an altercation involving a student, resulting in the defendant being placed on 6 months suspension without pay, in which he was required to complete anger management training for using unnecessary force against a 16-year-old student, is proof that the defendant has a history of using excessive force.
Mind you, this man is 6 foot plus, 200 and something pounds.
250 pounds, he said,
250
in the
pounds,
deposition.
and an alleged martial artist.
In the deposition, he said he was 250 pounds
250 pounds.
and currently on steroids.
Oh, yes. That's right.
In the deposition. You can read the deposition if you want. Go ahead and pay for Pacer and get it, since you don't want to believe the Moors. Some top city elected and appointed officials said previously to the city manager, Kevin Murphy, that Pender should be fired. It was also quoted in the article that Officer Pender could not offer any plausible explanation as to the origin of the marks and bruises on the victim. Also, a 16-year-old got marks and bruises on him.
He on the wild.
Which, if you read the article, you'll see where the cop, David Allen Pender, ordered all the other students out of the classroom, and then later couldn't explain the marks and bruises on the student. Oh, okay, so we can't use our common sense and deduce what happened.
Can't put 2 and 2 together?
The history of the use of excessive force is evident in this case, as I was punched 6 times in the face and body slammed on the ground while in handcuffs by the defendant. To wit, my claim constitutes one upon which relief may be granted. See article from lowsun.com by Christopher Scott, published January 26, 2017 at 12 a.m. Updated July 11th, 2019 at 12 a.m. And here's the source right here. Fact number 3. As stated on July 23rd, 2020, under oath, the defendant, David Allen Pender, is on record stating that he operates under color of law, a clear violation of federal law 18 U.S.C. 241 and 242, and Article 6 of the Constitution, which states that all laws of any state contrary to the Constitution are notwithstanding. So, oh no, the cops didn't say that they operate under color of law. Oh, you don't? Okay, so you still don't believe the Moors, huh? Okay, let's go to page 57.
This is crazy.
Let's go to page 57.
Like,
Let's go to page
They admit it. They don't even care.
57, where David Allen Pender. Oh, look, Leonidas Bear Bay, Free Moorish American National, just in case you missed it. David Allen Pender, who's a low cop, says on page 57. So let's go to page 57. That he operates under color of law.
You smoking a cigar over here? You got a cigar?
Look, he was asked, do you operate under color of law? Right? COL, you operate under color of law? Answer, yes. Question, okay, are you aware that that's federally against the law? Answer, I have no clue.
He don't even care.
Okay, one second. Did you take an oath, right? Did you take an oath to the Constitution? Well, did you? Let's see what this law enforcement officer who claims to be on the force for 33 and a half years states. And look, then his attorney try to interrupt. Wait, you mean today?
What?
So he's been a cop for 33 years, and you think he's asking if he took an oath to the Constitution today?
Today, stupid.
Nah, yesterday.
Like, and these are the people who want to try to say we're incompetent.
Right. So look, this cop who was a cop for 33 years says he doesn't recall what's the question they ask you at the time when you become a cop, even though you're required to take an oath. And the question, it's not even a question, it's a statement. They say, repeat after me. Exactly. And then they say, state your name, and then your dumb ass says, I, and state your name. Do solemnly swear to uphold, support, and defend the Constitution for the United States against all enemies, foreign and domestic, or something like that.
Yep.
So you've been a cop for 33 and a half years. You know the penal code 98 point whatever for the lane change thing, but you don't remember that you took an oath to the Constitution.
Yeah. Oh my God.
Okay, so you're dumb. I know it's to uphold the laws of this state and the Commonwealth of Massachusetts and stuff. Okay. Right? So that's what we're quoting. All right? I don't recall what's the question they asked you at the time. I know it's to uphold the laws of this state and the Commonwealth of Massachusetts and stuff. So I don't know exactly what they ask you the day that you're sworn in. So he already knows he's sworn in. To what? The Constitution. Again, that was almost 34 years ago. Right? So he said, yes, he operates under color of law. And then we put federal law, deprivation of rights under color of law. And how it's a crime.
Sounds about right.
In a Commonwealth, which he said, Commonwealth of Massachusetts. Oh.
Where else would you put that?
Oh, so you straight up